We do have quorum. Good morning, everyone. Calling this meeting to order. As chair of the committee, first I want to welcome you all and a warm welcome to members of the public and those watching live online. As usual, I'd like to remind everyone that you can find the agenda for today's meeting and follow the meeting in real time at www.toronto.ca/council. For those of you who are in the committee room and would like to follow the proceedings of the meeting, we have the TV screen in the back that provides real-time updates concerning where we are in the agenda and what's coming up next. The Licensing Standards Committee gratefully acknowledged that we're meeting in the traditional territory of the Mississaugas of New Credit First Nation, the Haudenosaunee, the Huron, Wendat, and home to many diverse indigenous peoples. Conflicts of interest. Are there any declarations under the Municipal Conflict of Interest Act? Well, seeing none noted. Can I have a motion to confirm the minutes of April 18, 2017? Councillor Burnside. All those in favor? Carried. Thank you, John. And list of speakers. Green sheet. And okay, we have, let me go through the agenda, and I'm going to hold any items that we have speakers. The first item on the agenda is amendments to Chapter 693 signs, Article 2, election signs. We have a deputant, so that item is being held. And item 2, that's a graffiti management plan, the StreetARToronto 2017. And I have a recommendation on that one, so I'm going to hold that item. So those two items are being held. Also, we have communications that have to be added on to the agenda and need to be introduced. And one communication is dated April the 27th. And it was, I believe that all the members of the committee have this one. And it comes from Mayor John Toy and the chair with regards to the regulatory framework to allow year-round full Patio Café enclosures. So can I have a motion to, just hold on for a second. There is another communication as well. No, let me deal with this one first. So this item needs to be introduced and to be added to the agenda. I would like to move the Councilor, Deputy Mayor Glenn DeVermaker. All those in favor? Against? Carry. If we can dispose of this item as well, what I would like to do is to refer this item to city staff, as they are working already on it, and to report back at the same time in terms of public deputations and public knowledge that have to be given. So I would like to refer this to staff. All those in favor? Against? Carry. So that's disposed of. Thank you. Just to share with you, there is a communication from Gail Suter, and that's from the Big Taxi. And this communication is before it was sent to the members of the committee. Couple things there. It's out of order to begin with because members of the public, they cannot introduce any motions. The motions have to be introduced by members of the committee. In the absence of that, we cannot do that. And number two, we are still within 1 year when the bylaw was passed, so this would be out of order. So this motion cannot be introduced at the moment. I will deal with that at the next meeting. So that's in terms of clarity on communications that are before us. Do we have any other communication? If not, we'll move to the we'll move to the speakers. Item number 1, LS 19.1, amendments to Chapter 693, Signs, Article 2 of the Elections Act. And we have, before I call for public speakers, I think that city staff, they're prepared to make a presentation, and I think that's going to be extremely helpful to all of us to have that presentation from city staff. So I'm going to invite city staff to make that presentation to the committee, and then we'll have an opportunity to ask questions and whatever else. So we have the Executive Director of Municipal Licensing Standards, Ms. Cook. Councilor Carichanes, do you have a point of order? Let's listen to it, and then probably we can go through the deputations and then ask questions at that point. Okay. Thank you.
I also have a quick point of order, Mr. Chair. I missed, I guess we approved item number 2.
Yes.
The grants. And I just have a request for next year. I think these grants give us some of the best public art we have in the entire city. So I don't know if next year we could have maybe a short PowerPoint saying, over the last 2 or 3 years, these are the 60 murals that we've commissioned, and here's just how spectacular they are.
Deputy Mayor, I second that item is being held, but in terms of your comments, I couldn't agree with you more, and what I would like to request actually that a presentation be made at City Council, because that's, I think in terms of the street art, this is something the most proactive, progressive things ever that's happening in StreetARToronto, so I think that's important for all members of council and the public to see what's happening. So probably we can do that at City Council as well. But the item is being held so we can have. Okay, that's fair. So good morning. Good to have you here.
Okay.
The floor is all yours.
Great.
Please go ahead. We're ready for you.
Good morning, Mr. Chair. Thank you. 2 quick things. I think appropriate to say Feliz Cinco de Mayo, since we're here on May the 5th. That's the fullest extent of my Spanish, and or Mexican, I guess. And I'd also, how did I do?
Just perfect, without any accent. Your Spanish much better than mine.
I tried in
Compliments.
Ecuadorian,
Please go
but I don't
ahead.
know what my luck would be. And while I have a microphone, I would like to just take an opportunity that I've not had in the last 2 meetings to introduce one of the newest members of my director team, Rod Jones, who is seated back here. Rod is our new Director of Bylaw Enforcement. He's got the Licensing Enforcement, Waste and Parks teams. So you'll be seeing him around a little bit more, and he'll be taking care of all of your issues. Well, at least the ones that Mark's not taking care of. Just some, not all. All right, so good morning. I'd like to take you quickly through what we are recommending as amendments to the election signs provisions in Chapter 693, the bylaw dealing with signs. This has been through this process previously. We're going to walk quickly through the background, review the process very quickly that we've undertaken, and then go through some of the proposed changes, and away we go. So just by reference, we were asked in May of 2014 to review the provisions governing election signs. We did report back through this committee and subsequently through council in August of 2014. Because we were so close to the time for the 2014 municipal election, a decision was taken by council that we refer the item be referred back and we come back at a later point. That later point is now. Through the substance of this report, we hope to respond to the directives we've been given, really with an eye and focus on establishing a more efficient and effective process to the manner in which the election sign issue is governed. Simplicity and clarity is what we're seeking, and a minimization on administrative burden, both for city staff and for candidates through the election process is our goal. We know through our experience that the manner in which the bylaw is currently constructed and the way the process currently operates tears up a significant amount of time by everyone, as I've mentioned. Multiple city divisions, many staff, a lot of processes involved in some particular aspects, which I'll get into further. So the goal, as I said, administratively right now, the process is inefficient, ineffective, cumbersome, and confusing. So we want to try to bring some simplicity. I can also share that the way the process is now is not only administratively burdensome, but really doesn't, the monies that we do end up recovering in a very minimal amount don't even cover the administrative costs, let alone the enforcement costs. So it really needed a refresh and a review on the effectiveness. So in the past, and as I mentioned, we brought this forward in 2014, we dealt with having public consultations. We had some great input from their jurisdictional research, and also there were outstanding items from an Auditor General recommendation and Ombudsman's recommendation in relation to the processes. Lastly, and at the very end of the presentation, I'll touch briefly on an item that I know is of great interest, and that's in respect to some of the amendments resulting from the Municipal Elections Modernization Act. So I'll speak to that at the end. So what we're recommending, I'll start with the display, the time period for that the election signs can be displayed. So what we've provided to you in this presentation, and hopefully you all have a copy, is what the current provisions are, and they do differ between federal and provincial, municipal, and even as it relates to election signs on campaign offices. So what we are seeking is consistency on the municipal elections and on the campaign offices to reflect 21 days prior to the election day. You'll note currently it's 25. The move to 21 days is as a result of the prior recommendation or direction we received from committee when this was brought forward in 2014. We're also proposing some language for clarity where that 21st day falls on a date of religious or cultural significance. We want to embed the flexibility in the bylaw to give effect to the next applicable date. This did happen once, I believe it was maybe the 2011 election, where it fell on a date that was problematic. So we just want to have bylaw language that ensures that people will have clarity on when they can start posting their signage. So in order to give effect to what all these provisions are, we've created a new definition that encapsulates these timings, and we're calling it the election sign period. It's simply the period of time during which an election sign may be displayed, and includes the period of time until which they can be out until they have to be removed, which is 72 hours after the completion of election day voting. The biggest administrative changes rely on this issue of the deposit, the fees, the waivers. Currently, there's a $250 election sign deposit required that is refundable based on the submission of an affidavit if there have been fees assessed due to signs being improperly placed. The process as it is involves city clerks, MLS, legal, our policy, planning, finance, and admin, finance staff, a lot of people, not to mention a lot of confusion and lack of clarity on the side of the candidates who aren't sure how to do the affidavits, when to do the affidavits, and to what extent do the affidavits apply. So there's a lot of confusion in this regard. What we are proposing is the elimination of the deposit fee. And just further on that, when we brought this forward in 2014, we actually recommended a $125 non-refundable deposit. But we also did hear from a number of candidates who are not necessarily incumbents, but are people who have smaller campaigns, and they spoke to the economics of their ability to participate if a fee related to the permission to post election signs was too great. So certainly this is for your discussion and direction. Our suggestion is that we don't remain in the refundable deposit process anymore based on the administrative challenges we've had, that if someone is a candidate for an election, that they're open to display their signs in accordance with the bylaw without a fee being required. Currently, we also have the fees that are applied when we seize signs that are improperly placed. Again, this has resulted in us compiling invoices, bills for those fees. Those were the ones that were typically or were subsequently waived through a waiver process. A lot of disruption, and we know when signs go out, signs can get moved. And every year that we have an election, and I just went through this for the first time in 2014, I got the calls, I heard the issues, I heard the concerns, people saying that their signs had been properly placed, but some persons had moved the signs, thus putting the candidate into an illegal sign position, us seizing the signs, and it becomes this circle of collection, display, collection, display. So the removal of the deposit hopefully will eliminate a barrier for those who seek to enter the political campaign process as well as eliminate the need for waivers and refunds, et cetera. Along that line, we currently have fees that speak about and the length of time that we will store or when we will dispose of election signs. Currently, we say we'll hold them for up to 30 days, that the signs may be retrieved as long as the amounts outstanding for the costs for us to recover them are paid, and we destroy them after 30 days. In this last election, we really attempted to work with the candidates to turn those signs back over, have the candidates address any improper placement issues, but also where signs were seized, making them available for candidates to recover them and put them back out in circulation. So our proposal is, instead of a 30-day hold on election signs and subsequent disposal for those that are not recovered, that we will simply hold them for 72 hours after the election sign period, and then they will be destroyed. This will eliminate the issue of us holding off yard space for storage of signs that ultimately are destroyed after the fact. But as we did in the 2014 and embedded in this proposal is that we will be providing notice to candidates whose signs have been seized during the election time to allow them to retrieve them and put them back out in circulation. So just for a summary or an overview of the timing, we're saying that election signs, once the election sign period commences, we're proposing that's 21 days prior to the election day, that there's an additional 72 hours that the signs may remain out after the election day, that we will hold the signs for another 72 hours, after which they will be disposed of. And we've had a great partnership with our colleagues in solid waste who have done everything they can to recycle these, whatever parts of the signs could be recycled, they have done that. So now one of the issue that raises itself through every election is, where can I put the election signs? So we're proposing clarity on where election signs can be placed, and you'll see between my discussion on public property and private property, we are endeavoring to eliminate that imaginary line, as it were, to some extent. There's one caveat on here, and I do have to give credit to Councillor Nunziata's office, identified an issue around requiring consent. We do believe there's a motion that we are seeking to be introduced that amends actually our proposed amendment and retains the responsibility or the requirement that the owner of private property give consent. So I thank Councillor Nunziata and her staff for identifying that. Currently, we have differing placement issues where there's on a highway where there's a sidewalk or where there's not a sidewalk. And we've heard stories through 2014, and when this report came forward, especially in Scarborough, we have large swaths of boulevard and a sidewalk maybe 5 meters up, and we don't permit election signs in that space because it's a highway with a sidewalk and a highway. And I always have to consider my colleagues in Scarborough. So we're proposing simplicity of the rules, just that an election sign cannot be placed within 1.5 meters of the curb or edge of the pavement and cannot be within 0.6 meters of either side of a sidewalk. No differentiating between highways that have or do not have sidewalks, therefore, enabling some additional space for the permissions for election signs. Our focus on these still remains that sightline obstruction needs to be avoided. We need to ensure that our pedestrian clearways, our intersections, are not obscured by signs, so the requirement that these be 15 meters back of those still applies, and certainly in respect to general election conduct, that the election signs cannot be near a voting place. Those are existing provisions. We're suggesting we retain those provisions. On private property, obviously, as I've indicated as well, for public property placement, it has to be with the consent of the private property owner. We did have a provision that said people cannot display election signs indoors if they were, and the size requirement, we're eliminating that. So if people want, especially people with small properties that want to display a sign, but maybe are within 15 meters of an intersection, this will open up an opportunity for them to support their candidate of choice, allow them to post a sign on their property in their windows. So a pretty simple simple change there that gives greater flexibility to people to participate. We currently have a provision with the TTC dedicated advertising space. We're just suggesting that we amend the bylaw to include street installation dedicated advertising space. So I'm glad my friends from Public Realm are here. Certainly if a candidate seeks to procure space through Astral Media with the arrangement they make with them, but it would be permitted. So it's expanding a permission beyond just TTC dedicated advertising and including the dedicated advertising space on our street furniture as applicable. Well, we create the permissions and you choose to avail yourselves as you can. So one of the issues that arose in the 2014 election as well was the wrapping of vehicles. This seems to be a very popular mode of advertising across business and everywhere else. Well, it did come up in the last election period, and there was a great deal of confusion, so we felt it was a good idea to embed in this bylaw clarity that would be deemed an election sign would be permitted on a vehicle or trailer, but certainly they cannot be parked in front of voting stations, they cannot be parked to obstruct sight lines, visibility, et cetera, but just allows what we know some have had an interest in doing in the past. We have currently a provision dealing with billboards. We're seeking an amendment simply to bring some clarity and more up-to-date language in respect to how we reference billboards, making reference to the Chapter 694 that governs billboards where permits are required. This also will include an amendment that addresses third parties who may now advertise on behalf of candidates, which we'll speak to a little bit later. One other piece that we've had issues with in the past is the notion of a campaign office sign. There has not been explicit provisions in the bylaw to differentiate an election sign from a campaign office sign. Again, this has been something through experience. We've heard that confusion of when is an election sign, and if my campaign office sign is one or not. So what we're proposing is to create a definition of what a campaign office sign is. And we've provided here that it indicates simply the name of the candidate and their location, but cannot contain electioneering or campaigning language. So if you have an office, Jim Karagianis, it can't say vote for, please elect, until it's in the election sign period. But your name on the billboard or on the office sign would be fine. It applies to all. No, that would be considered, I think that we'd have to talk about party logo, so we'll talk to legal about that. I believe that may lend itself to be considered electioneering potentially, so we'll have to let you know. Sorry? They're more than entitled to do so, but we'll make sure we've got clarity on that. That's a great question. So the point to it is but actually this gives rise to exactly why we want to have a definition for this. There needs to be clarity. People need to understand what they can and cannot do, what is within the context of just a sign versus an election sign. So certainly if there are any other items like that you'd like us to have a look at, that would be great, and then we can bring some clarity. There is one thing that was in the report that we need to have amended was just on the timing, just a little technical confusion issue. But again, the campaign office sign, we're saying would be permitted during the election. Once the candidate has registered to be a candidate, the sign can go up. I think that was it for that. Okay, party logo, we'll take a note. Okay, the last component here is in respect to the recent amendments to the Municipal Elections Act. Just for clarity, the only aspects of this that we are presenting are the a couple of provisions to recognize this permission in the election sign bylaw as it relates to election signs. So what we are proposing is adding a definition for these now permitted, subject to the MEA and your discussions, the third-party advertisers, and the election signs being referenced as outsider election signs. So creating definitions of what those are, differentiating from the candidates' election signs, require that these third-party or these outsider election signs are required to comply with all the regulations regarding first-party or candidate election signs, require that the signs can be posted only after the third-party advertiser has registered with the clerk, and that they have to be identified on the sign. Those latter 2 points were expressly stated in the amendment to the Municipal Elections Act relative to election signs. So the report and the amendments you have in front of you give effect to these new permissions. And just on that last point, and I do understand there's still some discussion to be had in regard to the amendments that have been made to the MEA, and my understanding is that that subject, in a more broader sense, will be subject of a future report, either from the city solicitor, the city clerk, both, one or the other. Our piece of this was simply to address the election sign component as we were addressing the broader issues that we've got with the administration and enforcement of the current election signs bylaw. So I will leave you with that. And I'm happy to attempt to answer questions.
Thank you so much for your presentation. Probably in terms of questions, as I mentioned at the beginning, is let's hear the deputants, and then if the members of the committee are okay, and then we'll get to the questions. Are we okay with that? Great. Thanks so much for your presentation. So I'll call the first and only speaker that I have in the list, Alan Kaspersky.
Morning.
Good morning, sir. Good to have you here. Thank you for coming. You have 5 minutes. Please go ahead.
Good morning, councillors. My name is Alan Kaspersky. I'm with the Green Party of Toronto, a municipal electoral association. I want to speak to the report, specifically page 10 of 12, item 8, amendments related to changes in the Municipal Elections Act, third-party advertising. But I'd like to relate a story to you first. Years and years ago, I was a chief referee for rugby at the University of Toronto. And I'm refereeing a game between Engineering and Innis College, and the game's going along fairly well, until I notice there's a woman playing. Now, this is a men's league game, and there was a woman playing. And I looked, and I recognized her. She was a provincial-level player, a very good flanker. But I looked, and I went, wait a minute, this is a men's league game, you can't play. So stop play, and I asked her to leave the field, which she did. Subsequently, got called into the dean's office at U of T in the phys ed department, and he asked me why. This was a fairly simple question for me. He asked me why I ordered the player off the field. And I said, she's a woman, she can't play in a men's game. And I was told in no uncertain terms that if a woman wanted to play rugby in the men's league, they should be allowed to be. Now, we had rules at the Ontario Rugby Union that said we weren't allowed to referee a game like that because there wasn't a lot of women's rugby at the time. The answer I was given was that the university would much rather deal with an insurance claim if she got injured than deal with a lawsuit for discriminating against her as a woman. Why do I bring that to your attention? You're faced with a very similar situation. Third-party advertiser, as Ms. Cook will tell you, is defined in the MEA as an individual, a trade union, or a corporation. We're none of the above. We're a municipal political party. We're a group. Now, this would apply to a residents' association, could apply to a lot of different groups. In our case, we have very specific advocacy roles in a political arena. Just like they have municipal political parties in British Columbia and Quebec, we have been trying to convince the Municipal Affairs Ministry here in Ontario to register us. Why is this important? Ms. Cook, in her presentation, talked about the size of signs, timing of signs. As a municipal electoral association, not bound by the third-party advertising guidelines, we don't have to wait till 21 days. Our signs will go up May 1st when the election's called. The 1.2 square meter sign size, our signs will be 3 times that size. Our candidates will comply with all the guidelines. But as the party, as the association, we're not a third-party advertiser. We don't have to register with the municipality, with the province. We're not bound by the guidelines about how much money we raise, where we spend it. We don't have to report on who we get money from at all because we're not required to register. So, timing, size, we can have, I guess, our own discussions about what would make sense for us as a party. Party, association, kind of interchangeable terms. So there's an easy solution. And I've suggested this to the clerk, to Elections Toronto, to the province. Register us as a municipal political party. Don't have to reinvent any wheels. There's a very simple process that Elections BC does. I've spoken to them. They'd be very happy to talk to Elections Toronto, Elections, the clerk here in Toronto, to show how easy it could be done. Some people will suggest, and the clerk certainly has done that to me, to us, she doesn't have the ability to do that. The MEA, Section 12, Powers of the Clerk, suggests that she does. If there is something that is desirable, and that's an interesting kind of discussion, or necessary, she could register a municipal political party, or parties, because I can suggest to you that I know of at least 3 or 4 that will be active in the next municipal elections here in Toronto. Why we believe it would be necessary, because the alternative would be not to register the party, would be to have those people take the city to court under the Constitution, the Charter. The Charter says freedom of expression, freedom of association is a guarantee. Right. There already is a court case.
Please try to wrap up.
Sure. There's a fairly simple solution. But if you don't want to deal with the solution, what you're going to be faced with is our signs going up, as I say, May 1st.
Thank you.
Thank you.
Questions? Councillor Burnside.
Thank you. Through you, wouldn't the other solution be to change the definition of a third party?
Absolutely. If you can get the province to change the definition of third party, you could do that. It wouldn't be something the city would be able to do arbitrarily by itself.
No, I understand that.
Yep.
But
we have suggested that as being the definition of British Columbia is group or individual. That would be the simplest definition. What the province did when they amended the MEA is they took the definition from the Elections Act. So not only would you have to amend the Municipal Elections Act, you likely would have to amend the Provincial Elections Act as well about the definition of third party. Can't tell you, Councillor, why they would have narrowed the definition like they did, other than it had probably something to do with an old definition on campaign contributions.
okay, thanks. And then my other question is, wouldn't it be somewhat counterproductive to whatever, well, in this case, your cause, but any cause, to start putting signs out 5 months ahead of election time?
Respectfully, not to combat the incumbent advantage that you folks have. Name recognition is critical, ground game is critical and that kind of thing. The complicating factor this next year will be that the provincial election will be underway at that time. So it wouldn't make sense that you'd wait till after the provincial election. But any opportunity to have the name of the party, the 47 candidates who will be running for the party, 48 candidates, would be a good thing from our perspective. Do we think it'd be confusing people? Not at all.
Okay, thanks.
You're welcome. You're welcome.
Thank you. Any other questions? Thank you for your presentation.
Thank you, Chair.
Do we have anyone else in the audience that would like to speak on this item? If not, we'll bring into staff. Questions to staff? Vice Chair Karygiannis, followed by Councilor
Thank you,
Bernstein.
Chair. Currently, we have a restriction on how big a sign can be. The city was taken to court back in the 1960s. Was a decision, City versus McKay, about how big the sign can be. Do we have any information on what happened with that court case?
From the
60s, yes.
Sorry, through you, Mr. Chair. I don't have it myself from the 1960s. I do know the bylaw does provide for size requirements or restrictions, but I'm not familiar with that case. I don't know if our...
I can speak generally. It's not a case that I have intimate knowledge of, but I am aware that there was a case that challenged restrictions to erection of signs in federal elections by municipalities. Our view is that that was under a completely different regime and worked as a prohibition, especially on the placement of election signs for federal elections on private property. So we're talking about a very different context than the current election signs bylaw.
Other questions that I have of staff. When, we clearly know when a person becomes a candidate municipally. Do we have clarification when a person becomes officially a candidate federally or provincially?
So through you, Madam Speaker, she's right there. Through you, Mr. Chair, we have tied the permissions for election signs for federal and provincial to the day that the writ is dropped.
In your presentation, you said the day the writ, where is it? Sorry, in your presentation, I think you said the day the person is a candidate, if I'm not mistaken.
Yeah, so, and my apologies if I blended between that for the purposes of the election signs versus the campaign office sign.
Okay, so a person, so the day the writ is dropped, you presume that that person is the candidate and he or she can put up signs?
For the purposes of the campaign office sign, yes.
What about signs on people's private property?
We've used that same date, the date the writ is dropped.
So then you're assuming that the day the writ is dropped, that person is a candidate, correct?
For the purposes of sign display, yes.
Okay, and if I was to tell you that the person is not a candidate until 21 days before the election officially, would you have anything to say about that?
So I can share with you through the chair, I can share with you that in respect to the federal and provincial elections and as it relates to election signs, we have not had substantial issues in regards to sign placement with the current regime. Where our greatest challenges have been in respect to the municipal elections. Certainly I'm sure that's as a result of the number of candidates in that regard. But the provisions here in respect to federal and provincial actually are not changing from what we had what is currently in place and has been in place for some number of years.
Okay, but you didn't answer my question.
So I'm not making a discern whether they're a candidate or not in respect to the timing for federal or provincial because we have allowed the permissions from the date the writ of election is issued. And the matter of candidacy within that period has not factored in for the purposes of election sign placement previously.
So if a person is running as an independent, federally or provincially, and they put up signs, do you consider that person to be a candidate?
Yeah. Well, it's not a matter of a candidate, it's a matter of if they are a candidate, if they are entered in a federal or provincial election, at the point the writ is issued, sign placement is permitted.
Right, but if they're placed if somebody says I'm running, he or she is not, if running as an independent, is not officially a candidate until they file their paperwork, which is around 21 days before the election with the returning officer.
And I'll just jump in here and note that the bylaw does define a candidate to be someone who is running or has expressed an interest in running for a municipal, provincial, or federal
So
campaign.
this officially then doesn't mean it is a candidate, expressed interest.
Expressed an interest, correct.
Why are we going down to 21 days versus 25? Don't you think that that gives the incumbents an overwhelming advantage?
Through you, Mr. Chair, that was in response to the direction we received from Licensing and Standards Committee and Council in 2014, and certainly that is a matter for your discussion now.
Okay, another question that I have for you, you're saying that when you're putting up signs, they have to be 1.5 meters in from the highways or the streets, and then behind the sidewalk, 0.6 meters.
So currently, yes, we have those provisions that wherever a sign is placed, they cannot be within 1.5 meters of the curb or edge of the pavement, or within 0.6 meters of a sidewalk. Those provisions are there to ensure public safety, personal safety, and mitigating obstruction of sightlines.
Now, what about if, let's say, between the sidewalk and the house is backing onto a major street and there's a fence, and there's about a foot only? Are you going to be allowed to put sign on a fence, on the back fence of a property? Still considered a private property, but it's less than 0.6 meters?
Through you, Mr. Chair, we have had that in prior elections, and we have permitted it.
Well, currently moving forward, that you're saying it's got to be 0.6 meters between the sidewalk.
So that's actually consistent with the rules that currently exist.
Right.
We've just clarified, we're not differentiating between a highway with a sidewalk and a highway without a sidewalk, but permission on fences. And those provisions are really there to address public safety
So
hazards.
if it's 0.4 meters, you're not going to go take the sign down from a private property back fence?
No, sir.
Okay, thank you.
Thank you, Vice Chair. Any other questions? I got questions. We have Councilor Burnside next. Please go ahead.
Thank you. Through you to, to whomever. What's the current registration fee? I know it used to be $100, but did it change for candidates?
Through you, Mr. Chair, for the purpose of elections, the election sign deposit is a...
Sorry, not election, just the registration as a candidate. Would you know that?
That I don't know.
Okay, that's fine, because I don't either.
Clerk, be able to help us?
And if
Okay, whatever.
our city solicitor knows the fee amount, or city clerks, we're looking it up.
We'll look it up and get back.
It was
Not a huge issue. So of the number, I think you said there are 226 candidates for council, correct?
I believe that's what we had in 2014.
Of those, how many violated the sign, the rules as it pertained to the placement of signs?
So in 2014, we received 27 affidavits, so seemingly 27 of the candidates
So about 10%?
on the
12%?
affidavit received, yeah.
About 12%, okay.
That seems low.
And so
That seems
if you,
very low. Let me file affidavits. Sorry, just for clarity, that's the number that filed affidavits, but certainly the number that violated the sign bylaw, we don't have that exact number.
okay, from your experience, would you say it's 50%, 40%? This, just a general, I just need to.
30-ish percent,
Okay,
probably, yeah.
that's fine. 30%, okay. And in, so if you, and so there's a $250 sign deposit that you're recommending that we no longer collect, or the city no longer collects.
Correct.
So what would the procedure be for if someone violates the sign rule? I don't really understand. Is it just we seize the signs and say, have a happy day?
So through you, Mr. Chair, currently that is generally the approach where the signs are seized, and there are enforceable provisions in the bylaw. If there are flagrant violations on an ongoing basis, we do have the ability to lay charges.
So in your opinion, are we not reducing the motivation for compliance?
Through you, Mr. Chair, I don't. I think generally the issues we have and the issues we want to focus on are those that obstruct or impact public safety. And we're going to deal with those irrespective. Okay. We have found that the administering of the current regime with a refundable deposit, waivers, where people are swearing that they didn't place the signs, is far more burdensome than and would not impact, or does not impact, the amount of enforcement we need to do. We still have a significant enforcement challenge. We had about 24 MSOs, officers involved in the 2014 election. We operate on a complaint basis. I don't expect that the fee actually impairs that.
Doesn't have any sort of motivating factor. Okay.
I don't believe it does, sir.
So you don't, so I guess I'm a little confused because previously, I thought there was concerns or concerns were expressed by candidates that might have a smaller budget, that $250 was burdensome as a deposit. So if money is an issue for those candidates, would fines not be an issue for those candidates as well? Potential fines?
So to you, Mr. Chair, I guess that would infer that those candidates would be operating outside the responsibilities in the bylaw. I can share with you that this is what we did here. The smaller campaigns and their concern of costs just to have the permission to post signs. I don't believe that there's a corollary.
Okay.
But certainly that's up to you if you feel a fee.
Yeah, no, I'm just again, trying to get your professional opinion. Okay, and then the last question I have comes back to Councillor Karagiannis's, or one of his questions about this going from 25 days to 21 days. I understand that was previous council direction, if you will. Two questions surrounding that. Do you recall the sort of the general consensus as why 21 days was picked and not 20 or 8? No, thank you. I understand there's that, but I'm trying to figure out why 21 days and not 18 days or whatever the case is.
Right. So actually, through you, Mr. Chair, there was at one point discussion of reducing it to 14 days. But there's also the concern around, fair access for people to participate. And certainly, and I know I can see our city solicitor is dying to get in on this, the concerns around freedom of speech and ensuring people have.
Okay, so sorry to cut you off, but I want to get one last question in. Sure. And the city solicitor can jump in as long as I get my questions in. I don't care how long you take.
That's good.
Last question.
Yeah, no, I'm on my last question, and now I'm like all stressed. So do you right what the rationale of council was from, so I understand about going from 20 to 21 days, but why move? I know Councillor Karagiannis and I have opinions as why council made that decision, but was there anything articulated in the debate that you recall as to why they changed it from 25 to 21?
Yes, through you, Mr. Chair, I actually do recall that it was our unfortunately recently departed Councillor Moser, who was a member of this committee, that I believe raised that issue of the number of days, concern around the proliferation of signs, period, and the impact that has on the community character, and just signage, period. The issue of signs has a very pro and con feeling for people. Some people feel signs should be open season, and others feel they should be significantly restricted. So I recall there was that blend of how many are out there. And there's also, from a practicality standpoint, a significant drain on the MLS resources, honestly, for the length of time that we have to deal with sign issues. And having experienced it in 2014, the first morning, the first 10 minutes, I had a phone call about an issue related to election signs. And so I actually lived through it. So, I think there was some consideration around the amount of resources that are expended to deal with improper placement, the look of the neighborhoods and the proliferation, as well as
Okay.
that.
Well, I can infer that 4 days made a difference in people's lives.
Yeah. No, I mean, it was, we don't want it to be arbitrary. Yeah, you're going to do more questions. It's not intended, we can't be arbitrary, we can't be overly restrictive, and we need to find a balance.
Okay.
And certainly that's up to you what you think is reasonable.
Thank you. Is any?
Yeah, and I'll just sort of follow up on that point that is the important consideration when adopting restrictions to the signs, not just the time period, but all restrictions to signs. These ones, of course, are democratic discourse, the most fundamental aspect of free speech, and council should be very, very comfortable with the decisions it makes and the rationale for making them.
Thank you. Councilor Musiera?
Yes, so on page 2, where it says the Ombudsman and Auditor General question, the signed affidavit. So is that what you were just answering to Councillor Burnside on that point, that councillors were actually getting their fees waived?
So through you, Mr. Chair, there, certainly the impetus or the issues identified in each of those communications, the Auditor General was from 2007, the Ombudsman was 2011, both primarily focused on the process and the appropriateness of the fee waiver, that it was found in most cases the waiver language was simply that which was adopted. The waiver was signed as of right, or just as it was, and both of those independent offices felt that it was not a great process to have.
Okay, my second question is as far as campaign office signs. So if you have an office that's corner lot, so basically you can only have a sign on one side. You can't have it at the side of the building as well?
The current proposal does indicate one sign face.
Yeah. So if it's a corner office, it has to just be in that one, the front of the office, not the side of the office.
Unless it's a
Yeah.
continuous sign face.
Yeah.
Yeah, we also have some size matters. You know what, that's
So
a
it wouldn't
good
be,
question.
it wouldn't be included as one sign, it's actually included as two separate signs, right?
Yeah.
Yeah?
I think we'd have to look at, yeah, I think that would be fine. The provisions say one sign face, and whether it's a continuous sign face, I think we would seek some consistency with the way the sign bylaw 694 applies sign faces if it does. So I'll take that away. I believe it would be fine, but we'll come back to you with that.
I just wanted a
Good question.
clarification on that. Now, Tracy, the amendment that I'm putting forward this morning, which is a technical amendment.
Yes.
Can you just explain to the members exactly why we're doing this and what it means?
Certainly, yes,
And
thank you.
Councillor Palacio, this is the clarification of my motion? Okay.
I'm listening, Councilor
Yeah,
Murcia.
certainly. So to you, Mr. Chair, when we drafted, in the interest of simplicity, we were seeking to minimize the amount of requirements there were around the placement. One of those changes we had proposed in the report mentioned the not requiring the private property permission for property abutting public property. And when your office called and raised that, we recognized, especially since we're trying to get away from that delineation between public and private, and the responsibility, quite frankly, we put on private property owners to maintain the public property, that we ought to ensure that the consent of the private property owner that abuts the public property is obtained. That was a unintended consequence of our intention to remove it, so having it remain in place, the consent of a private property owner for the placement of a sign that abuts public property, we want to maintain.
So
So we're asking for that amendment to make sure that that's
Yeah.
maintained.
So that's the reason why I'm moving the amendment. Okay, I just.
Yes, correct.
Now, if candidates put up signs weeks before the 21 days, your authority as MLS, what authority do you have to remove them? Is it classified as litter?
Well, they're not permitted
So-
until they are permitted.
So you will
So the sign
remove
bylaw
them?
gives us the authority to seize them. We, at least in 2014, that has not been the experience. Generally, we have found that candidates in the elections adhere very well to the timing. It's just the placement that becomes a challenge for folks.
Yeah. Now, getting off the municipal signs, because Councillor Palacio and I actually were questioning this when it happened a few years ago when the federally, there was some sort of campaign that was going on. Was it the post? Well, I forget what it was, but all the MPs from one party had signs that went up like for 2 years around people's front lawns with their logo, with their name and their party opposing some, and I can't remember what it was.
Clean
And we-
trains, that's
Pardon?
the Clean Train campaign.
The clean, so at that time, we were told that there's nothing we can do about that. So what's, like, I don't know what the difference is.
So through you, Mr. Chair, I do recall
You recall that?
I do
Yeah.
recall that, and that actually prompted us to have a discussion around civic participation signs. And I know the discussion at that time was around whether what was being posted would constitute or not an election sign. It's the simple stating of their name, whether or not it was an election sign. I'm trying to recall if we actually resolved that or not. We have not brought forward a report yet to deal with civic participation signs. As I mentioned to Councillor Burnside, people are very polarized on signs, good and bad. I don't know if Mr. Lynch can recall where we landed.
Because I remember it had the party logo, the MP's name, and they were on front lawns for a year, 2 years, and there's nothing we could have
I
done.
remember that.
Yeah.
Last question, yeah.
Yeah, and I'll just confirm that in our view, they weren't election signs. They fell in that category of civic participation signs, and the executive director is correct in saying that that's something that still needs to be reviewed and reported back on in a future time.
Okay, thank you.
Any other questions? Not yet. Is any other questions on the first round? I have a request to go for the second and third round of questions, probably before we get to that. I have questions as well, and then we'll deal with that. To the questions of a follow-up to Councilor Monserrat's questions with regards to her amendment to, and this has to do with any signs erected on public property must have the consent of the owner on the abutting property. Now, my question to you is, especially within the urban environment within the city, most of the signs, election signs that are placed within city property, public property. And so I'm just wondering, in terms of the legality aspect, how do we obtain permission from the abutting property owner when most of the signs are placed within public property? So that's mainly in the former city of York, Toronto. It differs a bit in Scarborough or North York, where you have huge boulevards and so on. So I'm not quite sure how that's going to apply in terms, if anyone wants to challenge that, once this bylaw is passed and amended, there could be a problem from that perspective as well.
So to you, Mr. Chair, actually, the amendment we're seeking, Councillor Nunziata raised, was simply to keep what has been the existing requirement all along, where consent is of the private property owner that abuts the public is required. Was it missing in there? Yes. So we had proposed in the report to eliminate the requirement for that permission, but in recognizing that this could cause significant issues, especially in the urban environment, small properties. So this is simply, that motion is to keep what the existing requirement is, which is requiring consent of the private property owner. So someone can't come along and put a sign on the public property in front of your house unless you've given permission. That was not our intention, but that was the unintended consequence if we removed that requirement.
Thank you. Along those lines, the setbacks that are proposed within intersections, within side streets, and I'm referring once again to parts of the city, for example, in East York and York and parts of the province of Toronto, where the key locations, literally speaking, to place election signs are within corners. Now, most of the signs that are placed with already a setback of perhaps a couple meters or whatever, so it won't obstruct the sidelines for pedestrians or whoever. So I'm not sure the setback that you're proposing there, how that's going to bring anything into compliance. Because as I said, that irrespectively of if it's a municipal, provincial, or federal elections, all those signs every time are placed at, in the main and key corners.
Yeah, so to you, Mr. Chair, that 15, bless you, That 15 meters of an intersection or pedestrian crossover is the existing restriction. So that is not a change. We are maintaining that to ensure our sight lines, as Councillor DeBaremaker just gave, to ensure that intersection and pedestrian crossover sight lines are not obstructed. So that 15 meters is already what has been in place.
But my question to you is actually, that may work in Scarborough, but it may not work, for example, in my area. That if I was to observe the 15 meter setback from the intersection, that would be goodbye to all the key locations and all the corners. And actually that item was brought at City Council, and most members of Council felt very strongly about that.
Yeah, that was, yeah. To you, Mr. Chair, I recall dealing with this, and particularly Councillor Fletcher,
Yes.
on this matter, but we're dealing with it in relation to its placement on private property.
Well, that's the difficult part between what's private and public when you are referring to the small front yards that people have in front of their homes.
Right. But I think they're permitted on the private property, but on a highway, I think I'm missing, the 15 meters from an intersection is existing provisions, has been this way for.
So shouldn't that be clarified in terms of the definition that we are talking about major arteries or highways where that setback is required, but where you have side roads or minor streets like with the cul-de-sac, that kind of stuff, I find extremely difficult, even within the parking regulations. The parking regulations setback is 9 meters.
Right.
So I don't know how this can be applied.
So this is for placement on the public side, not the private side. So a private property, and I'm going to look to Mark and correct me if I'm wrong, but a private property that's within 15 meters of an intersection can have a sign. You just have to ensure you're not obstructing sight lines. It's 15 meters on the public property.
I think I'm running out of time, but my key question on that is, if we were to look at one property, for example, let me just share with you one of the main streets, Dufferin Street or Davenport, that you are very familiar with, where the front yards are very small, where by definition it's actually very difficult to find the property line. It can be the property line maybe 1 meter from the sidewalk, or it can be maybe half a meter or 2 meters. So it's difficult for anyone who is placing signs to know exactly where the property line is. And that's where the restriction that you're proposing will create some difficulties there.
Okay, so to you, Mr. Chair, actually, you just very well articulated why we are trying to blur the line on placement between public and private as it relates to proximity to the highway, the 1.5 meters from the curb edge or pavement edge, the 0.6 meters from a sidewalk. That's why we're trying to address some of that. The 15 meters from the intersection as it relates to this, we can have some further discussion maybe with you and look at the specific scenarios you're referencing and ensure, how this meets what has been either maintained or proposed for amendment here. But I do recall that we went through this in 2014 and felt that we had this structure did take into account those types of small properties issue, but we can look at that further in advance of council.
That's fair. So having said that, I have a few other questions, but I think we're going to go through the second round. Vice Chair Karijanis, please go ahead.
Thank you, Chair. Through you to staff, I'm going to go back to the corner office that Councillor Nunziata was mentioning. So you got a corner office and it has two sides in an intersection. The display sign that you put on, it might have like two sign cases, and so if you're saying only one side, does not allow you to put on the other side. So I guess what you can do is just take one large sign and just wrap it around. I was wondering if an exception could be made where their sign is already there, signage, and you're taking over an existing office, that you are able to use the existing signage that, in a corner office.
So to you, Mr. Chair, I think that's a unique situation that we will look at how this provision applies, and it may not be necessary to make specific exemptions about where someone has taken over an office where the sign already existed. I see that as problematic to enforce or to define. So we will come back in advance of council to ensure we've got a clear answer for you on corner offices, campaign office signs,
Now, the,
on the sign faces. One per street.
yeah, well, it's, there is, we are allowed to put up signs 21 days before. So if we open a campaign office in June, we're only allowed to put sign on the wall outside the campaign office, or if it's, let's say, it has a frontage, can we put signs in the property of the building?
You mean the front window type of?
Front window, in front of your, you know, in front of your, on the lawn. There's these signs now that you got that they're based in, and, you know, it goes up and it's like a wind type, like a sail.
Oh, yeah, right.
Yeah, I mean,
So through you, Mr. Chair, the provisions here deal with election signs, and you cannot post election signs until the election sign period has commenced. We can certainly have a discussion about other signage, as
Okay.
long as it doesn't
So let me-
conflict with this.
through the chair to Ms. Cook, other signage, I just put my name up there and just block where it says counselor.
So this is where it depends on where we are in the election cycle as well.
June.
Right.
We registered in May, June, you got a campaign office, you put your sign up on the top, and you got some signs that say, John Burnside, Glenda Bearmaker, Jim Karagianis, nothing else, and just you put that sign in, out in front.
Yeah. So through you, Mr. Chair, we do have, so the sign bylaw, other than dealing with the election signs specifically, does deal with other temporary signs. So we would have to look at this all the provisions in the signs bylaw to determine whether it's an appropriate temporary sign. That's where we govern mobile signs, A-frame signs, and the rest. And then we'd have to look at whether what you have posted falls into an election sign issue and then subject to this clause. So it's a little difficult. I mean, ultimately, there's got to be compliance with the varying articles.
Can you please specify the wraparound vehicle signs, how far away they should be posted from a place where you vote? I mean, I know that you, during an election, you can put a sign beside a school on private property, but on voting day, you know, you can have a van and you can go and park right outside a school. How far back should these vehicles be stationed?
Okay, just your indulgence for a moment, Mr. Chair.
Can you put-
We do have provisions regarding the proximity of election signs, which a vehicle wrapped would be considered an election sign. As it relates to the voting place, I'm just checking the exact requirements.
You do have
Just said
requirements.
adjacent, right?
You do have requirements, okay.
It just, sorry, through you, Mr. Chair, we've not specified a distance. It references adjacent. That's for the vehicle, yeah, same as the signage. So any election sign cannot be placed adjacent to a voting place.
Okay.
On or adjacent to.
My other question is that we got 3 days after the election to collect the signs.
Correct, sir.
Now, let's say the election was held today and you got three days of bad weather. What happens? Well, you shouldn't be out of luck. I mean, you know, I mean, we do have to say that, look, I mean, for the next 3 days, it's going to pour like the cats and dogs. What,
So through,
you're going to get wet more than I do, and I got more hair than you do, my friend.
so through you, Mr. Chair, certainly we allow that provision, which is consistent with what we have now, those days to collect. And if outside of that period, certainly we will seize and we could charge. But I think the important thing to note in this is throughout is we attempt to work with the candidates.
However, you attempt to work the candidate now, 10 years from now, new person comes in, whatever. Can we put some language in there that says weather permitting? I mean,
I
would
don't
you be
know
amenable
that.
to it?
I don't know that that would be necessary. What I would default to, sir, is how we approach enforcement writ large, is with an element of discretion. given the circumstances that arise. So if we're in the middle of a hurricane, I would suggest that any person of right conscience would allow for
That
an
was your last
additional
question,
time.
Councillor. Is you have
One quick, I guess.
no, no,
another-
you have 7 minutes already.
Yeah, you went to 8.
No, we can go to the third round, one at a time. Thank you. Is any other questions?
Yeah.
Councillor Nuciana.
Because of the answer you gave to Councillor Karygiannis, the question was asked, can we just put our name up? And so this is a crazy question. What about councillors that have constituency offices with their names on it? Do they have to cover it during the election period?
No. No, so they,
So they're allowed to have their names up?
right, that's why we've created the definition for a campaign office sign. So, you know, I think of it as a transition from constituency office to the period where, you know, the election time is happening, you become a
but-
campaign office.
There is an advantage because they have their offices there.
Well, through you, Mr. Chair, there would be nothing precluding any other person from procuring a place of business and putting their name on a sign, as long as they follow the existing sign rules in 694. Yeah. No, it's a great question. Yeah.
I mean, especially when you got a
It's a
corner
great-
office, constituency office, like
Thank you.
colleagues across.
Any other question? That's it?
No, I would just add, though, through you, Mr. Chair, I do recognize there's a balancing of interests. We're trying to deal with simply some simplified rules around the signs.
Any other questions? If not, okay, I'm getting to my second round, Jim.
You said any other
It's
questions?
a follow-up to Councilor Nuciara's question, actually, that initially she asked. During the last few years, especially with the provincial and federal elections, there was a tremendous campaign with the Clean Train Coalition campaign, and that was with the color of the signs clearly identified the party that they were behind, and that was preempting actually an issue that was going to be dealt with during the campaign. So that was one way of effectively campaigning for years is on that item alone. So my question to you is, what kind of provisions do we have to stop that? Because I think that it was a very bright way of putting something forward. Any member of council, I guess, or from other party can just, or level of government, can simply come up with something very smart in terms of having signage that it doesn't conflict with the act, but at the same time, it will give you the advantage of.
So through to you, Mr. Chair, and I'll also invite Mr. Lynch to respond. As we had referenced earlier, my apologies if I didn't give a clear answer. That issue that you've referenced was really an issue and a discussion that we need to have around civic participation signs as a subject matter. Your point in respect to government parties being identified, it was determined in that particular case, they did not classify as electioneering language or election signs. This is a matter that we have had on the books to address since probably that time, but we have not as yet landed on it. So we do end up, and I think Mr. Lynch referenced previously, considerations in respect to the charter, but I'll ask Corey to weigh in.
And to be clear, part of that analysis is dependent upon the fact that election signs regulations apply essentially during an election, during a campaign. So some signs that may appear to be positional or political in nature that appear outside of an election period are not governed by the election signs rules. As the Executive Director has said, these would be considered more civic participation signs, meaning that they are signs that people put up to express political positions, not during a political campaign, and that is something.
Thanks, Corey. So that will, literally speaking, allow members of council to do the same thing throughout the term, anytime. It can be a no speeding sign, for example, or a slow down sign with your name on it, and that's one way of promoting the name of the incumbent or whoever else.
And to be clear, that's the issue that has been identified as a consequence of these types of signs, and again, a body of work that needs to be delved into. The executive director is right to note, again, there are charter issues with that type of signage and that type of expression, and I expect that a package of regulations would be necessary to address those signs in particular, and that's not currently subject to this report.
Thank you. Is another question to the solicitor. I do expect, or the committee expects to have a report before council from you, correct? Would be feasible to have any positive or negative impacts on the third-party campaigning kind of style and the consequence of it within your report?
That's correct. That is our intent, to address third-party advertising, the impacts of the amendments to the MEA, as well as potential challenges as we were directed to in December by council.
Thank you. Now, within that, with regards to the third party, is there a criteria to identify who the third party will be, and how is that going to be determined in terms of registration?
So
With some sort of cutoff date when they have to register, so city staff will have enough time to figure out who they are, especially with those fly-by-night supporters that very often they will come with a publication or a magazine or whatever, and they use it for that purpose.
And I can confirm that the amendments to the Municipal Elections Act do, in fact, require each third-party advertiser to register with the city clerk before they engage in third-party advertising. They also have a restriction on when they can advertise to a specific period, starting in the nomination period, and as well as spending limits and contribution limits, as you'd find in a candidate situation as well.
The spending limits will apply to the candidate or to themselves?
There are spending limits for both the candidates as well as third-party advertisers.
No, I understand for candidates, but for third party, like as one of the deputants indicated, that they don't have to report the amount of money, where the money comes from, or how the money is going to be spent, which was an excellent comment by the deputant. And so that's the information that's extremely crucial in terms of having that. It will benefit incumbents, but will put newcomers at tremendous disadvantage.
And I will confirm again that the Municipal Elections Act amendments include provisions to require compliance auditing functions similar to a candidate for third-party advertisers. So there are similar processes conceived of in these amendments for those third-party advertisers in regard to their contribution, spending, and activities from a financial perspective.
My last question, and with regards to advertising on vehicles or trailers. If, for example, if one has friends that they have transportation companies, 1 or 2 or 3 and whatever else, as some members of council have, and or we have close connections, there is going to be a cost to it in terms of the operation of it, the cost of displaying signs, and for how long they may have to do that. And so is there some sort of follow-up on that that will be clear, concise, and enforceable at the same time, that will apply to the same rules like the third party?
So if I understand where you're getting at, I believe that the MEA amendments are clear that those sort of contributions would be contributions regulated under those spending caps and contribution limits.
But that's not in the report, though.
That's correct. These are amendments provincially, so they exist, and when they come in force, will exist due to the provincial regulations.
Can you bring that information forward to council, please?
Certainly.
Thank you. Vice Chair? Yeah, okay.
Through you to staff, have we had a robust consultation with current incumbents, with people that run previously, people that you can still get in touch with regarding the proposed amendments?
So through you, Mr. Chair, we did not hold consultations directly with candidate officials. We did have a public consultation when we brought this report previously in 2014. It actually included a number of people who had previously run for office, but not our current office holders.
Do you maybe find it prudent that we might want to wait the summer and have a conversation with current as well as past people that run in 2014 and have a robust conversation? I mean, like,
So through you, Mr. Chair, I think that is the purpose of this process, Councillor Karygiannis, is to present what we feel will be appropriate to mitigate the current administrative burden of the current process, to give effect to some of the requests we had previously in 2014. We had hoped to have brought this report previously. Unfortunately, other matters held it back. I believe that this would be the most appropriate venue at this committee, where we do have a gentleman here who's come forward. We have had deputations in the past. I don't know that an additional consultation specifically with elected officials would be easy to hold. Certainly clerks has rules around meetings. So, you know, I think we're in a good place as far as putting these recommendations in front of you, myself.
Through you to staff, I beg to differ, and, you know, it's my opinion, but I think that if we're to move forward, I think that you need to reach out to current federal MPs, provincial MPPs, people that ran before, and I think you need to have a robust conversation.
What's the question?
The only thing, excuse me?
Please, the question.
There's a question in there.
About
Because the only thing that I kept hearing was a federal member of parliament was screaming and cursing about the municipal legislation around signs. So I think that you might want to sort of think about the possibility that we put this off until September and you take the summer to consult.
That's not a question.
That's not a question, that's, you are making
Said I think.
comments, that's your
What would
speech.
you- And what would you say to this?
so,
Oh, that was an excellent question.
Let me finish.
Wouldn't you agree? Wouldn't you?
to you, Mr. Chair, we have consulted with representatives for the various groups you've referenced. We do have the benefit of having yourself, having previously served in the federal realm in this discussion. So I feel very confident that all interests are being represented. And I can share that we have found that the provincial and federal elections have not posed sign issues. So the current regime, they're fine with. The proposed regime really simplifies and creates a little bit more clarity. I don't feel additional consultation with current or prior MPs or MPPs is necessary for us to advance this file, but I will appreciate your input from your past experience.
My last question is this. If there is a request that comes from provincial and federal MPs, MPPs, and party, would you then be willing to hold consultation?
So
We should listen to them because we put motions in here so they listen to us.
through you, Mr. Chair, as with all of the work that we do, we are always open to hear from people who are interested and have a position. At any time, we have an email address that we offer people to provide feedback, and certainly we are all very reachable by email as well. If someone would like to contact us and have a discussion about their concerns, they were more than open to do so during this time as well as in 2014. And certainly as this advances, hopefully from this committee to council, there's the opportunity for the input directly to you. So our door is always open.
Thank you for advising us of that.
Great. Now we have speakers on the item. Okay, we have hands up, Councilor Burnside, followed by Councilor Nunciara, Deputy Mayor De Veramaker. Please go ahead.
Thank you. This has gone on a long while, so I'll try to be brief. I do have a motion. I share Mr. Kaspersky's concern about the incumbent advantage, although I wish I had the opportunity to ask him the question, what happens if an incumbent affiliates himself or herself with the party? That would just further strengthen the incumbent's advantage. I wish I had that opportunity. I didn't. In any event, life will go on. So I want to maintain, I'd like to maintain that 25 days. Through my questions, it seems to me that council's, the thrust of council's desire to go to 21, I found the number of days 21 to be very arbitrary and the rationale weak. And the last thing I want to do is further strengthen an incumbent's advantage.
Thank you, Councillor. Is questions to the mover and Vice Chair?
Chair?
Yep.
Go ahead. Thank you. Through you to Councillor Burnside, would you consider a friendly amendment instead of 25 days, to say 30 days?
Sure, whatever you like. Thanks. Anything greater than.
Why not 6? Why not 100?
Okay. Is any other questions?
Down?
Come on, Councilor Sierra, we're not debating between ourselves. There was a question of clarification. Any other questions? If not, the speakers,
course
the next
there are, but-
speaker, Councilor Sierra, you're next.
Yes, I will not be supporting Councillor Burnside's motion. We went through this debate, how many years, Councillor de Bearmaker, people that were there? Hours and hours and hours. There was even debate about even getting rid of signs at one point because of the proliferation and the garbage. I'm speaking. I don't have a question. No, I'm speaking. So I just want to move my amendment that I mentioned earlier, that Tracy mentioned, and just put it on the screen. So basically, that's what I'm moving, and it was clarified by Tracy. And then, as I mentioned, asked the question about the campaign office sign. Maybe you can report back on that, just in case, just so there's clarification on that, if it comes up in the next election, so it could be answered. So basically, that's it. I don't have anything else to say.
Thank you, Councilor Sierra. And the next speaker is Deputy Mayor Glenn. There is no motion. We have a question from the mover.
Through the chair to the speaker, in a lot of communities and former municipalities, the owner goes right up to there's no sidewalk, so the public property is 36 feet from the middle of the road. So when you put up a sign, I take it you also mean that the abutting property is closer to, to the edge of the road. This is something that this intends to address.
The way it is now. I'm not changing anything. It's just
No,
the
but
way,
I'm not saying to change.
yeah,
but
it's
what
just
you're-
the way it is now. There was just a technical amendment in the report, and that's what I'm correcting.
Okay, thank you.
Yeah, okay.
Any other questions to the mover? Councilor Burnside?
Just a very quick one. Would consent be verbal or written? You said you want,
In writing.
must have the consent of the owner.
Consent. Oh,
Verbal is fine?
Verbal.
well, yeah.
Okay.
Because you know how many times people just put up
Thank you,
signs and you
Councilor
go to
Sierra.
the owner and the owner says, well, I didn't tell them to put that sign up. They just
Thank
put
you.
it up because they seen your sign. Then you got 20 signs there. Okay.
Okay, the next speaker is Deputy Mayor de Bearmaker. You're next.
Thank you, Mr. Chair. I'll be supporting the staff recommendations, and I won't support extending the sign time. My preference, given that it's 2017 and we're going to have an election in 2018, is not to have signs at all. I'm an environmentalist. I would expect the Green Party, of all people, to come here.
Green?
No, I'm an independent locally, but I'm a well-known environmentalist. What a waste of resources and money election signs are. All of us feel, I don't want signs, And some people said to me, well, Glenn, you're an environmentalist. Are you going to practice what you preach and not have signs? And I've said, you know what, I'd like to have no signs, but unfortunately, I'm forced to have signs because all of my competitors and all the mayoral candidates and all of the other candidates have signs. So if you don't put up signs, or I feel compelled, because if I don't put up signs, people think, oh, you're not doing anything and you're not canvassing. I see this guy's signs all over the place. I see them on every intersection, but I guess you're sitting at home watching TV while the other guy's out canvassing and campaigning. So I have felt compelled since first being elected in 2003 to do the sign campaigns. It irks me as an environmentalist that all of us spend collectively across the city probably tens of thousands of dollars creating plastic, using finite resources, creating greenhouse gases to put up signs for a month, using inks that are probably not very good for anybody, putting them up for 25 or 30 days, and then throwing them in the garbage. We couldn't even recycle them until the last election. So I have found the signs are an adequate way. Maybe back when we all had horses and buggies, and there was no such thing as the telegraph or the radio or the TV or the internet. Maybe back then, when, you know, the fur trappers would come up and down the Humber River and the Don River, maybe when the fur trappers were here, we needed signs to let our residents know that there is actually an election going on. But we have this thing nowadays called TV. You can't go to the dentist's office or to the Canadian Tire or to an auto place without seeing a screen on the corner with a news broadcast running 24 hours a day. There's this thing called a flyer. We go to printers and we print them out and distribute them. So I have never liked signs. I don't want signs. I would personally eliminate signs. But I've heard the arguments about freedom of expression and the ability of people to have an awareness and, quote, educate people. So I'll accept the staff recommendations. I see them as an incremental change to an existing election sign bylaw that overall worked pretty good. I'm glad to see that we've taken out some of the administrative measures that were really cumbersome and awkward, didn't work very well, and all of us have been in the situation, I've been in it myself, where we actually argue with the MLS staff because we know we put up a sign properly, and yet they'll say, oh, no, that wasn't. And when we go back out to the location with the inspector goes, oops, I'm an inspector and I made a mistake. You're right. This is private property. I thought it was city property, so we took down your sign. So I hate wasting my time during an election campaign having to correct some of our municipal standards officers, telling them that they've made a mistake. It's just a silly dance that everybody does. To have the affidavit that everybody knew was just a license to waive all of your fees. So we have this, in theory, penalty system if you disobey the law. People knowingly and willfully disobeyed the law, and voila, came up with a candidate saying, I didn't know that my sign crew that put up 1,000 signs was doing them all incorrectly. Really? You didn't know that? No, because I have an affidavit that says so. So I'm glad our staff have had the experience and the maturity to say, you know what, the sign deposit for the sake of $250, this accountant's nightmare of counting every single sign at every single location that may have come down and calculating how many days it's been in storage and calculating that plus the interest and not allowing you to use Visa. I'm glad the staff have put in this report. Let's get rid of a system that wasn't really functional. Let our staff do more important things. And that's why I'm going to support their recommendation to go to 21 days, because it is a huge volume of time going after election signs. I'd rather have my inspectors in apartment buildings going after cockroaches and mice and other vermin. I'd rather have them going out to auto body places that have illegal cars parked all over the boulevard and auto parts strewn all over the place, as opposed to them saying, well, let's go on a search for an additional week, for an entire month, searching for plastic signs that shouldn't be created in the first place. So I will support the staff recommendations, and that's it.
Thanks so much. The next speaker is Vice Chair Karjanis.
Thank you, Chair. I do have a motion that basically says that it goes from 25 to 30 days, the friendly amendment. So I want to thank you, staff, for putting this on. I listened carefully to my colleagues I hope they're paying attention to me. Thank you, Councillor Burnside. With regard to putting up signs, I think that as incumbents, that we've been here for 3 terms, 4 terms. Some of us have been in our awards in 2 lives, and that we have an advantage over people that want to challenge us if we limit this to 21 days. I see Councillor Burnside in the last election challenge an incumbent, and he was successful. And if he didn't have the opportunity to put up signs, as my colleague to my left, Councillor de Beermaker, says, he probably would not have been able to succeed. I think Burnside is on your side. That was a good one. I think that it's appropriate. It's appropriate to.
Please.
It's appropriate that we allow people that want to challenge us to put up signs. I think that they need the extra time in order for their names to be put out there. I don't think that we should not allow them to challenge us. I don't think that anybody here, if we're scared to be challenged, then guess what? Don't run next time around. I think that the incumbents should allow people to have a robust conversation, a robust challenge in order for them to be held accountable. And to people distribute literature. A lot of people sometimes don't pay attention to the literature. The signs do speak. They don't vote, but they do speak. They bring the name of the person that needs to challenge you forward. So I would ask my colleagues to carefully consider the 30 days prior to the day of the election. We don't have anything to be scared. If you go to 21 days, the only signal that you're sending out there, I'm the incumbent, I don't want to be challenged, I am scared to get challenged. I know why, summarize probably why the person that was sitting in this committee before the late Moser did not want to be challenged, because he usually went the very last day to put his name up, and past election results show that he was able just to squeak by the election. God bless him and rest his soul, and my condolences to his family. But however, I would say to you, let's be brave. Let's not be scared. People that want to challenge us, let them put their names out there. Let them be visible. And let our constituent decide. If they think that we're doing a good job, they will return us. If they don't think we're doing a good job, they will throw us out. 21 days to 30 days, it doesn't make a lot of difference to the incumbents, but it makes a hell of a lot of difference to people that want to challenge us.
Thank you, Councillor. Any questions to the mover? If not, Councillor Di Giorgio, you're next.
Yeah, just very briefly, Mr. Chairman. First of all, I will be supporting Councillor Nunziata and in her motion, and then the rest of the staff recommendations. You know, we've been through this debate before. One can make all sorts of arguments. The number of days for allowing signs to be posted, or at least to be used as advertising for all potential candidates, is an arbitrary number, no question about it. Now, the underlying issue that's been raised by someone that wants to extend the number of days is that for some reason it'll give the opportunity to someone who's challenging an incumbent greater opportunity to unseat an incumbent. The reality is that if an incumbent has been doing a good job, those people that believe he's doing or she is doing a good job are going to vote for that incumbent. No question whatsoever. You can extend it to 60 days. Pardon me? It's not got nothing to do with being scared. What it's got to do with, maybe you're under your motion, Councillor Karygiannis, we should be consulting with those people who are making signs and see whether, as a matter of fact, they'd love you. They'd say, well, the more signs we can print, the better. So extend it to 60 days, because that's good for the guys making signs. But if I have to purchase, let's say, 2,000, 3,000, 4,000 signs, at the end of the day, I'm going to generate waste. More waste, and that goes to Councillor de Beermaker's point. So, what's the right number? The right number is something that says, look, give someone a reasonable opportunity to advertise his name using signage, but the real opportunity is the guy's going to knock on doors. If somebody wants to challenge an incumbent, he's got to do work. Anyway.
Why do you keep interrupting?
Those are my comments. I mean, we can.
Don't let anybody talk. You have to keep interrupting.
Yeah, I was just getting started, but it really, you know, it just means people don't listen.
And Councilor Carichanis, please. The first motion is a technical amendment that I'm being asked by city staff to move that one. And the second one is for the city solicitor to report directly to City Council on positive and negative impacts on the implementation of the third-party advertising amendments. And through my questions, the city solicitor indicated that he'll be willing to do that, of course. Now, first I want to thank the city staff for the report. I think these are very mindful, thoughtful recommendations that we have, and also for your presentation. It was an amazing presentation. And the recommendations overall are excellent. Councilor Side, would you be kind enough, please? I cannot even hear myself. There are excellent administrative recommendations that brings so much value to it. To Councilor Nunciara's point and Councilor Giorgio, this item was debated to death at City Council back in 2014. And the only reason that was not approved, all the recommendations that most of it, you have it here, including the 21-day, it was that Councilor Moser, that by then, and he wanted the implementation of it. And there was a tremendous appetite at City Council to embrace that. But the reason why City Council couldn't do that is because there was not public notice given to the public. So we had no City Council through the chair is refer this item back to this committee, and that's why we're here with this report. And subsequently, with regards to the third party. Now, to the third party aspect, personally, I have serious concerns with and I would like to probably I will be holding this item at City Council to have a good discussion and a good debate on that aspect of the recommendations. My concerns with the third party simply have to do in terms of clarifying the regulations as it relates to it. And I'm concerned that there will be those powers to be out there with the big money, and I'm talking about developers and so on, that it will be so easy to divert whatever amounts of money to create a system where fly by night and supporters will come forward, simply try to help whoever the candidate is going to be. And I think in the absence of clear rules there, that's something that's clear, concise, totally unambiguous, where people have to register is on time, where city will have an opportunity to check who these people are. And I think that otherwise we'll be doing a tremendous disservice to those who are trying to challenge the incumbents. With the incumbents, we have the upper hand on this one, because I think the name recognition speaks by itself. In terms of, for example, that vehicles and trailers carrying your names on, the question is, who is going to pay for it? What kind of system do we have in place for accounting for that? It will be very easy, for example, in my area, I have 20 poles. How easy it would be for me to engage, and I'm saying, hypothetically speaking, engage one trailer per pole just to drive around and around and around. What a way of promoting yourself. Without a clear definition in terms of who is behind that, that will create something that's a disadvantage to those who want perhaps to unseat the incumbent. So I have some concerns with regards to that, and hopefully we can have a good conversation at City Council, or some changes through the report that comes from the legal department of City Council, just to address some of those concerns, just to tighten up a bit more the definitions so they are quite clear. Apart from that, I think that's, with regards to the motions that we have, I'm not going to support, I'm going to support just the recommendations from staff. I won't support except Councilor Nunciara's motion. Thank you. So we have some recommendations there. Can we display them, please? We have 3 recommendations from Councilor Burnside, from the Vice Chair Carigianis, and from the Chair, and from Councilor Nunciara. There are 4 motions. We are going to vote on it now. Can we display them, please? And Councilor Burnside's motion, and that's to increase the number of days from... Okay. Well, that's an amendment to... Okay, on the amendment from Councilor Carigianis, and that's to the motion of Councilor Burnside. Recorded vote, all those in favor? Councilor Burnside and Carigianis against? And the Maker, Palacio, Di Giorgio, and Nunciara. Defense. The next one. From Councilor Burnside, recorded vote, and all those in favor, Councilor Burnside and Councilor Carigianis. So this motion is in order. So in favor of this motion, Councilor Carigianis and Vice Chair Jim and John Burnside, I'm sorry. Against? Councilor Nunciara, Councilor Giorgio, Palacio, and the Maker. It fails. It fails. The next motion. Councilor Nunciara's motion. Technical one. All those in favor? Against? It carries. And there is one more. And the next one is from the chair, and those are the technical amendments. All those in favor? Against? Carry. On the item as amended, all those in favor? Recorded on the item. Councilor Nunciara, Councilor Giorgio, Palacio, and Councilor De Maker against, and Carigianis and Councilor Burnside. It carries. Okay, great. So this will take us to the next item. Is item 2, and do we have deputants? We don't have deputants on this item, but questions to staff? Questions to staff on the next item? If not, speakers. Speakers, Councilor Nunciara, or questions to staff? Councilor Nunciara, please go ahead.
Who's answering these questions? Oh, okay. So
One more.
all the applications that are recommended in the report, so all community groups and BIAs apply for this, correct? Like, are they given notice that they can apply for this?
Through you, Mr. Chair, that is correct. They are given notice. In fact, what we do is we do a roadshow in the 4 districts to meet with community groups and artists. We advertise it on Akimbo through our own websites. So we had at least 250 people attend a group of that group of sessions that we held this year.
Okay, thank you.
Any other questions? If not, I have some. Oh, I'm sorry, is Councilor Janis. Please go ahead.
This question is of staff, correct?
Yeah.
would we be able, or is there a mechanism that you can think about, if not now, for the future, should we have Section 37 money that we want to attribute to it, if that would be possible in order to enhance and not limit the situation?
Through you, Mr. Chair, we have done that on some projects in the past. We've also put Section 37 funding toward underpass, toward the underpass program, to the outside the box program. So certainly, if you have Section 37 dollars that are available, we're happy to work with you to find a direction
Thank
for
you.
those to create.
Appreciate it. Thank you.
Thank you, Councilor Janis. Any other questions? If not, I have a few, I guess. How many tags, in terms of graffiti, vandalism, have been removed? Do we have those numbers within private and public places?
500,000 square feet a year?
Mr. Chair, we calculate that we remove about 500,000 square feet of graffiti vandalism a year through the contract we have.
Is, in terms of numbers, though, locations, if you don't have it now, that's fine, probably for council, if you can get that information. I think that's very important to have that information. My next question is, how many murals do we have around the city now?
Mr. Chair, we have, up to 2016, we calculate that at least StreetARToronto has, from 2012 to 2016, and certainly there have been other murals created through BIA programs and through individuals on their own or community groups. We've created 365 installations. And of that number, 103 of them have been through the program, the partnership program, the grant program that's in front of you today. Our startup program, which is our underpass program, we've created 15. Our police program, 56, and the outside the box program, which paints traffic signal boxes, 191.
Fantastic. How many professional artists do we have within the roster, or are we employing to do all this art?
Mr. Chair, we have 130 artists who are on our street art directory who have signed up to be to make themselves available so that the public can access them or any other groups can access them.
So the numbers have changed dramatically from 2012.
Yes, they have. When people were hesitant to go on a city website, and from I think in the first year we were up to 30, and now we're up to 130.
130. So
Yeah.
okay, fantastic. How many youth are being mentored by all these professionals, these 130 artists that you're referring to?
Yeah. Councillor, I don't have a precise number, but I would say I can
That's fine if you
find
don't
that.
have it now.
But I can tell you that with the exception of the Outside the Box program, every project we do, whether it's an underpass program, a grant program, or a police program,
Thank you.
involves youth mentorship.
I have a few questions, and I am running out of time. In terms of the artwork, a tremendous amount of artwork has been created on walls, fences, underpasses, utility boxes, and you name it. And so my question is now in terms of street murals on the road within the pilot project that was approved by the Works Committee as well by City Council.
Yes.
How do you consider that kind of art in relation to the other art that we are taking so much pride?
Councillor, I would say that for us to have a great mural art city, we need a whole range of different types of approaches. And since 2012, we've added all these new programs, including the road mural program, which was quite successful last year.
So in terms of the street murals that were painted on the road, how many did we have last year? They were approved, I believe, 4, but...
There were 4 that were painted, yes.
And do we know how many were created, and how we monitor them?
There were just 4 that were created.
4. Was that pilot a success?
Councillor, I would say that that pilot was a success. We had concerns at the outset about the amount of staff time that might be involved in overseeing that, but the amount of staff time that was involved turned out not to be significant.
Great. I have just 2 quick questions. And will you recommend this pilot to be extended and also to be funded from the public realm, given the level of success?
Councillor, I'm in agreement that the pilot should be extended. There seems to be quite a bit of demand for it, and the funding can be secured through the Street Art Toronto program.
So this kind of art has been set up a positive precedent in terms of moving forward. Would be
I would agree
fair
with
to say
that,
that?
yes.
Thanks so much. No further questions. Speakers, Councilor Karigiannis.
Chair, through you to staff, there's a proposed mural that's coming up in my part of the world. We sort of missed the deadline last year, but certainly this year with staff, we have the guideline. This is a very important situation in my area where thank you, councillors. An individual was shot while sitting in a van, and we're trying to get the community together. This is the Chesterlee community, which is a TCH community. We were trying to get them together in order to be able to speak to what happened and to address the issues that are happening there. And we also had another shooting just recently. So I want to thank the staff for working with the community in order for us to be able to put that mural up.
Thank you, Councilor Karigiannis. Well said. Any other speakers? Welcome, Councilor Fletcher. I have a motion to move that, if we can display that City Council extend the StreetARToronto road mural pilot project for up to 4 mid-block street murals on low-volume local streets during street events, which include permitted road closures in 2017 and such material considers the honorarium to be covered through the Street Art program. This is something that was implemented by Council last year, and as when I asked city staff in terms of the level of success, it has been a tremendous success, this part of the street art, where the level of engagement within communities, especially when you have a street festival out there and the streets close, you have kids, families. It's a real civic engagement in terms of bringing the best of the best that you can have in the street and creating something beautiful. So I think that is, and I'm delighted and very proud that that we have played, all of us, and on that, Councilor Fletcher, and for playing a key role in the street art program. That's been the key and one of the main components in the graffiti management program that was approved by City Council. The street art program aims, as we all know, not only to develop, support, and promote, but increase the level of awareness of street art as it is known now, and also plays a key character in terms of beautifying our neighborhoods. And that's when it comes to promote creativity and cultural vibrancy. I think we should be extremely proud of what's happening throughout the city of Toronto. This program has been so successful, And I'm so grateful to members of council for supporting from day one. And I recall a few years back when everything was so gloom and dim, it seems like everything was going to die. And thanks to also to the vision and the leadership of city staff, we were able to bring something great at that point. It's not only the graffiti management plan, but also to embrace the arts community in such a way that what's happening now, we are creating a prototype that we can be extremely proud, and this has been seen throughout the world. So it's something well done. I'm extremely thankful to city staff for what's happening. I'm very thankful to members of council for embracing with so much passion all these artistic expressions that have been expressed throughout the years, and for embracing the arts community more than anything else. So that recommendation will complement something that is dear to people out there. They're asking for it, and this is something that hopefully that next year we'll be able to look at it and to say, what a beautiful thing that we did. So having said that, thanks so much, and hopefully that we'll have a unanimous vote on this one. Great. Thank you. So we have that motion there, and I'm going to ask for a recorded vote on this one. All those in favor? Yeah. Is Deputy Mayor Glenn DeVeramier, Vice Chair Carijanes Palacio, is Councilor Di Giorgio, Fran Di Giorgio, and Councilor Nunciara. Thank you so much. Well done. To adopt the recommendations as amended with that recommendation, all those in favor? Against? Carried. Thank you so much. A motion to adjourn. Thanks so much, everyone. Thank you.